good afternoon. And just one slight tweak to the title of the talk. It's rather than an analysis, it's really an initial analysis of the scheme for a Climate Action and Low Carbon Development Bill 2013. And the scheme for a Climate Action and Low Carbon Development Bill essentially refers to the recently published Heads of Bill in February 2013. And it's really the current government's first published substantive indication of what they have in mind for what a climate change bill, the long-promised climate change bill, would look like when it finally is passed into law. And what I'd like to look at in particular are two things. Firstly, just to give a sense of the overall model of this proposed piece of legislation and to offer some comments in relation to that. And secondly, to just perhaps an assessment from a legal perspective of the controversial omission of a specific domestic greenhouse gas reduction target as distinct from an EU target or a target under the UN climate regime. So, and it's an initial analysis, and it's kind of, in a way, somewhat speculative, because the heads of bill I refer to are really not even that. They're very early. They're quite draft heads of bill. And so, what's proposed now in the way of the model may well not, represent what's there at the end of the legislative process. But secondly, in relation to the omission of a specific target, I mean, there's a lot of rumour and suggestion around as to what the reason for that was. It does seem that at governmental level there was a big concern about leaving itself open to legal challenges and so on, and there's very little detail around that yet, but so I'm being somewhat speculative in looking at what challenges might there be potentially. So it's speculative, but nevertheless, hopefully you'll find it useful. And perhaps a useful starting point in relation to this is the current government's programme for government in March 2011 and its specific comment in relation to a climate change bill. It said, "We will publish a climate change bill which will provide certainty surrounding government policy and provide a clear pathway for emissions reduction in line with negotiated EU targets." And in my written text here, I have, after in respect of in line with negotiated EU targets, in italics, emphasis added in relation to that. And really, what I mean is that wording, in line with negotiated EU targets, seems to suggest a sort of an outright, it appears to avoid an outright commitment to surpassing EU targets. So we kind of, just offer that. And up to that point, what we had was, in the way of promised or proposed, rather, climate change legislation going back to 2000. There were a number of initiatives. A group of independent senators in 2009 proposed a bill. There was a Labour Party draft proposal, I think 2009. An Oireachtas Joint Committee made a proposal, a sort of suggestion or a model climate change bill based on international practice. And then we had the Climate Change Response Bill 2010, which published at the very end of 2010 during the death throes of the Fianna Fáil Green Party coalition. And as we know, that didn't proceed because the government didn't proceed. Really, all I would really remark in relation to those within the time available is that they all, in one way or another, had a proposal for a domestic target. It didn't seem to be questioned to any great extent that there would be a domestic target. Although certainly resistance to a target by the time of the 2010 bill was growing, although at that point, and you'll see this in my written paper, a majority of GDs had signed up to domestic climate change legislation in the principle of legislation. So then, change of government in March 2011, and then nothing really happened until about November of 2011 when the Minister for the Environment announced a review of national climate change policy. And that really appeared to be a sort of an 18 to 24-month timetable that involved starting in February 2012 a 2-month public consultation on what the public might like to see in climate change legislation. The National and Economic Social Council Secretariat, not the full council, were they were tasked with doing 2 reports, an interim report by June 2012 and a fuller report by the end of 2012 on really sort of firstly bridging the gap between our sort of 2020 EU target and secondly just what was called a basis for it was called well, I have the precise title with me, but essentially a basis for moving to a long-term sort of transition to a low-carbon future by 2050. And all of that process was meant to, if you like, inform long-term policy, but certainly was meant to inform the substantive content of a climate change bill. And then just moving on to the heads of bill published recently, what I would remark is that they are, while at a very early stage, nevertheless they point to a piece of legislation that will be highly unusual, I think, in Irish terms, in terms of structure and form, in the sense that they really omit any reference at all to substantive means for the reduction of greenhouse gas emissions. Really, what they appear to comprise is a framework for a further cycle of policy making as far as I can make out. I mean, that is the core head in the current heads 4 and 5. They effectively head 4 is titled a low carbon future, and it expresses what's called a transition objective, and that's described as a transition to a low carbon, climate resilient and environmentally sustainable economy in the period up to and including the year 2050. So transition to a low carbon, climate resilient and environmentally sustainable economy in the period up to and including the year 2050. And perhaps necessarily, I think, vague and unspecific in light of the omission of a specific target by which we ought to reduce or might reduce our greenhouse gas emissions by a particular point in the future, by reference to a baseline year in the past, say 1990. And so that's called the National Transition Objective, and to enable the state to pursue that, the government is required to arrange for the adoption and implementation of plans. And the principal plan is effectively a national scale plan. It's otherwise in the bill called a National Low Carbon Roadmap, or otherwise again a National Roadmap. It has to be prepared by the Minister for the Environment and submitted to the government for approval with or without modification. And it is to, and this is important, quote, specify the policy measures, unquote, specify the policy measures that the government, well, or rather that in the opinion of the government are required to, and I'm just paraphrasing, well, quoting here, achieve the management of net greenhouse gas emissions at a level commensurate with the national transition objective. So already you have quite soft language in there. You have this unspecific objective, a national transition objective. I mean, highly unusual for a piece of legislation to use the word even transition and climate resilient, low carbon without being quantitatively specific. All of that is highly unusual and almost unprecedented, I mean, in terms of an objective in legislation in Ireland. And so the link really is the transition objective, the government requirement to arrange for the adoption of this national roadmap that is to contain policy measures that, in the opinion of the government, are required to achieve the management, more softness, of net greenhouse gas emissions at a level commensurate, more softness still, with the national transition objective. And then, it says, ensure as a minimum compliance with any existing obligation of the state under EU law or international agreement. I mean, is that saying that, well, this bill really means that we absolutely have to achieve our EU target, whatever that may be from time to time? Apart from the fact that we don't need a piece of domestic legislation to tell us that anyway, we're required as a matter of EU law as a member state to have to do that. It's not even doing that in a way, in the sense that it says that the roadmap is to specify the policy measures that, in the opinion of the government, are required to, or rather, in the opinion of the government, will achieve the management and will ensure as a minimum. So it's really a matter of opinion from time to time for the government as to what will enable us to achieve it. If they get it wrong, I suppose the point is, and the point I would make is, that is not amenable to judicial review. And so, the plan also, or the bill, the heads make provision for sectoral plans. It's not clear what's meant by sectors. It seems to suggest departmental sectors, as distinct from sector by reference to source of greenhouse gas emission, residential, agriculture, and so on. And again, those sectoral roadmaps, and they're called for by the government. The government doesn't doesn't have to call for them across all sectors. And again, the relevant minister shall, quote, aim to ensure the achievement by the sectoral roadmaps, aim to ensure the achievement of the transition objective. And so, there's a whole range of matters that are set out that the Minister for the Environment in the case of the national plan, and the relevant ministers in the case of the sectoral plans, must have regard to, and many of them are quite countervailing, the usual ones, sustainable development, but otherwise, quote, the likely economic impact of a national roadmap, etc. And in fact, if you look down through them, A to K, almost all of them really read as, protect the economy here at all costs. And if you read the two NESC reports that I referred to, whereas they do specify that we do need to move to a new type of economy, there is still an awful lot in the two NESC reports and this heads of bill about protecting the, if you like, the conventional economy. So I think that, the issue is, and there's other heads in the bill, not too many others, but there's provision for a national expert advisory body on climate change, and I really don't have time to go into that, but that is the core model, if you like. And the question that I asked at the outset is, how far down the road does this bring us compared to what the proposals were over the last 5 or 6 or 7 years? And I really don't think it brings us very far down the road at all, and I think it could, even worse, it represents arguably kicking the can further down the road again, because really, I've sort of can't stress highly enough how sort of unusual a model that is for any piece of Irish legislation, any of the active Oireachtas to kind of look like that in final form would be highly unusual. It's not, of course, unheard of for an act of the Oireachtas to provide for strategic planning, and we think in terms of county development plans and the Waste Management Acts that make provision for strategic infrastructure, waste infrastructure, that type of waste planning. But they're very, very specific parts of the economy, and they're very, very specific kind of land uses. So here we have what I think is, a framework for further policy making. It contains no real substantive, not even one substantive measure for greenhouse gas reduction. Some legal questions that arise in relation to this. Well, I suppose I should make the point firstly. this bill, these heads are now presented in February 2013, almost 2 years after the government came into power. And let's say it will take the rest of this year into 2014 for a bill or an act to emerge. And, that's 2 years after this NESC exercise and the public consultation exercise, all of which was meant to inform the substantive content of the bill. And there was no inkling that this is the model that would emerge, namely, a national roadmap, in relation to policy measures when we've had, the successive climate change strategies. We have things like the Renewable Energy Action Plan, Energy Efficiency Action Plan, a whole range of these big, high-level strategic documents. And the fact that the heads don't even attempt to define what's meant by policy measures, they give no indication in relation to whether that is, for example, high-level policy or something with a modicum of legal effect. There's no distinction really. Is it a policy measure in the sense that the NESC document refers to this, which sometimes encompasses legal measures? There's all of this uncertainty in there. And the idea that you have an act of the Oireachtas making what's called a national roadmap, which will contain undefined policy measures, the relationship of what may be pure policy measures in that national roadmap to the act of the Oireachtas is entirely unclear. And I think how the Parliamentary Draftsman's Office is going to grapple with concepts like transition to a low-carbon economy and articulating a national vision. These are expressions that are used in the heads of bill, and these aren't concepts in the bill. They're not just language to just articulate the point in the bill. So really, I really question how far down the road we've come in relation to all of this. If what we're left with is a bill that will then trigger the making of a national roadmap and there's nothing in the bill to indicate what is the status of all the policy measures current in relation to greenhouse gas reduction and what will be the legal status of those that don't end up in the national roadmap, and in relation to any that might be implemented while the heads of bill are being debated or that are left out afterwards. There's a big question mark over that, because really measures that are to be in the national roadmap can't be implemented until the government approves the national transition plan. So there's a whole range of questions in relation to that I just question the model on. I just want to move on to the question of the absence of targets. And I mentioned that perhaps the softness in relation to this transition objective was referable to the omission of the targets. And in terms of the legal concerns that apparently the Attorney General's office and that existed at government level are concerned, as far as can be made out from newspaper reports and so forth, they kind of fall into broadly two categories. One of the constitutional variety, and second of the just the concern apparently on the part of the government that it would leave itself open to a raft of legal challenges if it wasn't able to reach the target, didn't look like reaching the targets, or if it had a specific long-term target with these periodic trajectory for reaching interim targets, it didn't look like reaching any of those. And so this was typical of a newspaper report a few months ago, just before the heads of bill came out. This is the irishtimes.com in February. The decision not to include specific targets for medium, long-term or partly influenced by legal advice from the Attorney General's office on the basis that they might be vulnerable to constitutional challenge. And it's been kind of difficult to get any sense of what might be involved there. I mean, I've considered whether the very concept of setting a target might be vulnerable to legal challenge. The very idea of having something specific, a specific quantitative indication or objective in the bill. And, you know, you can look at that question based on the varied understandings that exist in relation to what it means for the state to set itself a target. You know, if you look at it in the sense of it really doesn't mean anything more than, you know, something that the government should set out to endeavour to achieve. Is that constitutionally objective? That softness? Should legislation really something that's meant to have the force or the effect of law, you know, is a soft target or a soft objective objectionable in itself? And I mean, state practice would really suggest not, and there are numerous examples of really where the state and governmental figures are set quite soft, flexible objectives within legislation. Nothing as vague as I've been talking about earlier in relation to the transition to a low carbon economy, but you know, the Water Services Act 2007 at section 30 refers to the general duty of the minister to facilitate the provision of safe and efficient water services and water services infrastructure. And a starker example is contained in Section 2 of the Fiscal Responsibility Act from last year, which, you know, transposed the obligations in relation to the budgetary constraints on government. And Section 2 of that Act talks about the government shall endeavour to secure that the requirement imposed by Section 3, which was the budgetary rule, so the government shall endeavour to secure. And then to the extent that a stipulation of a domestic greenhouse gas reduction target might be capable of being viewed, you know, not really as aspirational but as a hard target, is that objectionable? And is that where the AG's office were coming from, if you like, in the idea of setting a target being perhaps of concern? And, you know, what one might think about here is the fact that, you know, public authorities do have a general duty in administrative law not to unduly fetter their discretion, and, you know, one can apply that to the idea of a long-term specific quantitative target in terms of greenhouse gas reductions, and looked at in that light, is that sort of objectionable? And again, you know, when I think about that, I can't see that as being problematic when you consider the facility there would be to amend legislation from time to time, and the UK Climate Change Act has nevertheless got around that potential difficulty quite cleanly, really, because, you know, in Section 2 of the UK Climate Change Act of 2008, which does have a long-term GHG reduction target of 80% by 2050, the Secretary of State is given the power to vary that percentage reduction and to amend the baseline year by order based on developments in scientific knowledge about climate change or developments in European or international law and policy. So that is just one you know, potential constitutional angle. One that I've given a lot of consideration to in the paper has to deal with the extent to which setting a specific target might be objectionable in terms of interfering with the exercise of property rights, constitutionally protected property rights. And we don't think about that a great deal at the moment, but, you know, because we look really at its sort of flexible mechanisms more so than hard regulation. But certainly in the decades ahead, it is certainly going to be more and more likely that there are going to be land use restrictions in relation to, you know, the need to really, really control direct emissions of greenhouse gases in terms of land use restrictions, and in effect treating carbon dioxide as in effect a pollutant with emission limit values and all of that, such as they're beginning to do in the US. And really I'm thinking to the potential for clash with constitutionally protected property rights. And, you know, it won't have, of course, escaped the Attorney General's office that, there aren't unfettered constitutional property rights in the Constitution. They are capable of being restricted in terms of what's called the common good and social justice, and we can perhaps think of the need to combat climate change and have an effective climate change response in those terms. And there are a whole series of cases, or there are a whole series of examples really of where the concepts of common good and so on have restricted property rights, compulsory purchase, compulsory acquisition of land, hours of trading, power lines across land, all of those many examples. And really, it would be a very easy thing for the government to simply, over time, consider the common good in terms of the need to have an effective climate change response. Where perhaps, the government would need to be careful in terms of reconciling greenhouse gas reductions and targets with property rights would be that whereas they have a great deal of latitude in determining what is the common good, when they go about restricting property rights, they have to do it in a sort of equitable way. And, there's, by way of example, sort of the case of Blake v. the Attorney General is referenced in the paper that I've written. And there, the Supreme Court held in the old Rent Restrictions Acts that legislation that placed controls on the levels of rent that landlords could charge in respect of certain properties represented an attack on the property rights of those landlords. And this was really because of how bluntly that regime operated. All of society has an interest in ensuring access to accommodation and access to proper education. But the Rent Restrictions Acts that were designed really, and the real policy measure, one of the few policy measures to achieve that, targeted a very limited class of persons to achieve that social objective. So those are the principles that come into play really when, the different sectors in this whole greenhouse gas reduction debate are set against each other. The agriculture sector, perhaps concerned at future land use restrictions, pointing to the flexibility that industry has under the EU emissions trading scheme to emit as much as they like, if you like. So I don't ultimately see that, for the reasons I explain in the paper, as being a problem, because first and foremost, I don't believe that sectors for those purposes are as blunt or as limited in terms of agriculture, residential, EU ETS sector, and so on. Okay. So, and I go on to explain in the paper why I think that the huge latitude constitutionally, almost a presumption of constitutionality that is enjoyed by tax legislation, creates huge potential, and how a much more expansive view of costs and matters like that give the government huge latitude in countering any suggestion that might emerge that, there has to be an absolute equal per capita rate of reduction, to avoid any constitutional challenge. I don't think we get anywhere near that territory. I just want to say a few brief words about the, I suppose, the concern that might exist about, the susceptibility of government to enforcement action or judicial review action if they don't look like reaching the long-term target or medium or interim targets. And in effect, the UK has been through all of this. These were arguments, in other words, that these are justiciable issues, and that somebody could sue a public authority or a minister of government if they didn't look like reaching their targets. And the UK have been through all of this. And effectively, what the UK Act has ended up saying is that it has this long-term target. It has interim budgets or targets, in effect, and that from budget to budget, if the Secretary of State, if it doesn't look like that an interim target is going to be reached, he has to, or hasn't been reached, he has to really go into Parliament and explain why that is so or why that's happened, and he has to set out the mechanism by which he will attempt to redress that in the course of the next budgetary period. And that is really how they've dealt with it. And they've said, look, that's the statutory remedy. The Act sets a target. It doesn't actually say, in the event of the target not being reached, the Minister will not be liable to it. It doesn't get into any of that. Because for one thing, for an act of the Oireachtas to say something, for it to say expressly, there cannot be any legal challenge in respect of this matter, is getting dangerously close to a separation of powers issue. So what the Act has simply said is very subtly, look, if the Minister misses a target, he goes into Parliament and he explains why that's so, and he says, I'll try to do better next time. And that is, in effect, the remedy. That is the corrective measure. And it's, in effect, a replication of what happens in international environmental law when you have targets. A state can't be brought into the International Court of Justice. States never let themselves open to that. They make sure to build in a corrective mechanism whereby they will, in effect, attempt to do better, and make proposals for correcting a situation, and that's it. And so, I mean, I articulate in the paper in section 5 really about that, and how it contains some, I think, quite some quite telling evidence from legal expertise before the 3 UK committees that considered the UK climate change bill before it passed into law in the UK on this specific issue. And despite the fact that government officials were going into the committee saying, if you like, giving the political message that these are going to be legally binding, these targets are going to be legally binding, we're very serious about tackling climate change. The committees didn't really buy that. They brought in legal expertise. One of the witnesses from the Public Law Centre at Cambridge University, Professor Forsyth, said, a target is not something that you can guarantee. It's something that you would like to happen, but you're not sure it will. So the duty of the Secretary of State is to achieve the target. To achieve the target is, at best, a duty to use his or her best endeavours to achieve that target. It cannot guarantee that the target will be achieved. The consequence that has for legal enforceability of this duty is that a failure to achieve the target does not, it seems to me, imply a breach of the duty. So there is nothing for the court to enforce, even if it were minded to do so. I am of the clear view that this is a duty that is unenforceable in the courts. And arising out of that and similar evidence before the UK committees, particularly the joint House of Lords and House of Commons committee, specifically formed to consider the bill, the committee recommended that the simpliciter statement in the bill to say the Minister has a duty to achieve the target should be changed, because it said that